Hi, I'm attorney Gregory Dell, and I'm here with Cesar Gavidia. And Cesar, we're going to talk about Lloyds of London disability denial claims and what your options are once Lloyds of London has denied a disability claim. And probably one of the tougher companies I'd say that we have to go up to when it comes time to deal with a denial. And more so, in my opinion, probably because of what I find to be their level of disorganization, in terms of just being such a gigantic conglomerate of a company that does so many different types of insurance, where disability is not one of their big ones, but they write like these surplus type policies that are kind of like, oh, we'll write some disability policies, and but we don't really have an in-house formal department to review them. We're going to use third-party administrators to always review these claims, and they use multiple different third-party administrators depending upon where it is in the country. And we've seen all of them, obviously having handled multiple Lloyd's claims all over the country. But when it comes time to deal with the denial, Caesar, what are the different options that are available for a claimant? And then let's also talk about how we go about handling those options.
Sure. So, depending on the policy, there could be a number of different options. The most kind of, common option that you're going to see is a kind of review or appeal process that you're going to go through. And it may be different levels of appeal. They'll describe the first level as an informal review, and they may describe, if they continue denying it at the informal review level, a different formal review level. Now you start getting into the question of, well, who reviews these things? So you have these third-party companies, as you said, either DMS, or you have McLaren's group, which is the one that I've seen most recently, really, doing these reviews. And typically, because I've been on the side of reviewing these denial letters from McLaren's and from DMS, they're not a big operation over there necessarily. So where is this going that you're really going to get a true independent review of your case? And I start reading through these denial letters, and I start to question, is it even really, this so-called claims examiner who's signing this letter who wrote this response? And as you and I know, these Lloyds of London policies are these surplus policies that usually have gigantic premiums attached to them with gigantic benefits. And you're looking at this very narrow window of time that these disability claims are getting submitted, right? Because the coverage window is usually only a few years in these policies. And I read through these letters and I'm like, this is how a lawyer writes. This isn't how a claim representative writes. They're throwing legal terms in and out of these letters. And that may be because of just the gigantic amount of liability on these things, and that that's really who's doing these reviews and making these decisions. So I wouldn't be surprised that through this formal review, informal review process, that's who's basically reviewing this. Is that you're looking at people with basically legal degrees, JDs, lawyers. People who have this basically legal background that are doing these reviews. The other thing that may happen is that you may not have any review process. It may go straight from a denial to you could sue them in federal court. Now, usually the only restrictions that you have is that you have to sue them in U.S. District Court in the U.S. And Lloyd's being a UK-based company, that's not an issue for an insured who's got a U.S.-based policy. You want to sue them in U.S. District Court and federal court in the United States.
Let's talk about some of our experiences with the very unique review process in which they take away your right to file a lawsuit in court.
Yeah, so now what you're describing is these kind of like forms of alternative dispute resolution that they basically bind you to when they sell you these policies, right? And what you're describing right there is arbitration. Okay, and arbitration is where you come in with your lawyers, they come in with their lawyers, and you have this panel, usually of about 3 arbitrators that are there, one selected by you, one may be selected by them, and one is one that you select together, or one may be one that's assigned through this arbitration board, this national arbitration board or something, and this panel of 3 arbitrators or judges are basically deciding whether Lloyd's has liability on your claim. Now, what's important about that process, and what a lot of people don't know, is that you're not bound like you are in U.S. District Court and federal court by the rules of evidence. So as lawyers, when we're litigating in federal court, we have very specific rules that we have to abide by in terms of the admission of evidence. With arbitration, pretty much everything is admissible, right? You could have hearsay evidence, you could have letters, you could have testimony from witnesses. All of those things are admissible, and it's sometimes a process that you want to go through, but other times it's like a kangaroo court. You're just you're kind of being set up for a potential binding denial of your disability claim,
and often without a right to appeal.
Right.
Which is a significant disadvantage, because in the U.S. District Court, if you lose, you can apply to the Federal Circuit Court, and then if you were to lose there, you could apply to the U.S. Supreme Court. So you have 2 additional levels of appeal, whereas with a binding arbitration, you don't. Now, sometimes when people are buying these policies, they have the option to choose between a binding arbitration or litigation, and the premiums are going to be less likely with an arbitration, but you have to be careful, because often Lloyds will want to try to stick in that arbitration provision because it's a lot less expensive for them to have to litigate an arbitration usually, and it's finite without any appeals or anything, so they just see it as a one and done type fight. So that's a disadvantage. The other thing we've seen, Cesar, is a kind of a quasi-arbitration that Lloyds puts in some of their policies, where they say, okay, you do an appeal after you disagree, and you're required to. Like, if you don't, then you haven't complied with the conditions preceding to coverage. So you absolutely have to do that. And let's assume you lose that appeal, which goes back to the same company. So it's kind of like an ERISA appeal. Then they have this thing, they say, well, here's how it's going to be resolved. You pick a doctor to give an opinion about why you're disabled. We'll pick a doctor, and then the 3 of us will have some independent doctor who's going to make the ultimate decision. So now they're leaving it up to a doctor who doesn't know anything about disability claims, who barely knows anything about the claimant's occupation, and is basically looking at the pure medical and making a determination as to whether or not that person can do their job or not. Has no training in the world of handling disability claims, really no understanding of the policy, and yet this doctor is supposed to make a medical determination. So not the best situation you want to be in, and clearly very high risk, because you don't know what you're getting, in that scenario. So the options are somewhat scary, but the great thing is when you have the scenario to go to court against Lloyds of London, that you're going to get a full-blown jury trial. And why is that so much better, Cesar, than the other options if you don't have a jury trial?
Well, when you have a trial by a jury, you're having a trial by presumably, peers, right? Now, these people are not trained insurance specialists, most likely. I don't see either side probably. Well, there could be an advantage to one side or the other wanting what may happen to be an insurance specialist on a jury, but you're most likely not going to get something like that, okay? But you're going to have people that come from all different backgrounds, okay, all different types of occupations, all different types of demographics on that jury. And they're there to assess basically whether, based on the evidence that's been presented to them, whether Lloyds of London is liable, okay? And there's so many different factors. Again, they're not looking at it necessarily strictly through the legal lens, like a federal judge or like a panel of arbitrators may be looking at it, right? They're looking at it through a human lens as well as a legal lens, or at least the legal lens as presented to them by the attorneys and by the evidence that's being presented. So, being litigators, being trial lawyers, we would almost always prefer to have a jury decide a claim or a case of disability involving Lloyds of London versus a panel of judges, or versus just a bench trial with a federal judge.
Right, and I love the cases against Lloyds of London when it comes time to go to a trial because they have very little support. Everything's contracted out. They're the big bad insurance company. And if you're a good plaintiff and a good person and you've been honest, you have the upper hand going up against them as opposed to them over you, because they just sold you this policy with this giant premium hoping to collect, and most jurors feel that way. And so you're going in one step ahead. And the way they're going to try to defend this case, as you know, is they're going to try to bash your credibility. They're going to try to make you look like a liar. They're going to try to video survey you. They're going to try to look at your your social media and all of that stuff. And they're not necessarily going to fight you on the medical, because the doctors, you're experts as the plaintiff, they're experts as the insurance company. The jurors know that your doctors are going to support you. That's why you're there. And they know that their doctors are going to support them. That's why they're there. At the end of the day, the case is only as good as how much they like you as the plaintiff. If they like you, very high chance you're going to win. If you're not a great plaintiff, it's going to be tough. And so that's a very simplification of a jury trial, but that's the bottom line as to what it's going to come down to. So we could obviously talk jury trial, theory and these disability claims, Cesar, from handling so many of these, and tell war stories, but the bottom line is that you have options, hopefully, with the Lloyd's policy. We've seen every scenario from the medical review, arbitration, through the jury trial. And if you're in this position with your claim, feel free to call Cesar or myself for a free initial consultation. We help clients all over the country. We've litigated these cases throughout the country. And we really look forward to the opportunity to discuss your case with you and let you know how we think we could help you. Thank you for considering us.